All right, let's do it. So I want to talk about the Carpenter versus United States case. I left my mic at the office, so I'm direct recording it. That's why it's closer. Thank you. I do need prompts like that all the time, so appreciate you looking out for me. So Tuesday's lecture was about general things in criminal law. We talked about different kinds of crime and the elements of those crimes. And then we talked about some of the constitutional protections that we have in the criminal area, one of them being the Fourth Amendment to the U.S. Constitution, which protects us from unreasonable searches and seizures, right? So over time, what constitutes a search has been interpreted differently by the courts in keeping with the times. So back in the day, when the Constitution was ratified, right, the idea of a search was very closely related to the idea of trespass. The only things that could be searched besides our person would be our homes. We didn't have automobiles, we did not have cell phones, we did not have online presence, we did not have anything like that that the government could go into without permission. It was mostly a physical idea, certainly nothing electronic. But over time, what is an actual search has been broadened to now include any area where we might have an expectation of privacy, not just in our physical locations, but in our virtual presence as well. So this case sets up for you the question of whether or not the government would need a warrant in order to get cell phone site location data from the cell phone company. So what happened in this case was that Mr. Carpenter was involved in a string of armed robberies, allegedly. And he was arrested for that. And part of the evidence that they used at his trial was records of his cell phone location that they got from the cell phone company. So they were able to get his records over a 5-day period. So they asked the cell phone company to send them 5 days of his cell phone location data. And when they got that, they were able to pinpoint his location in relation to all the robberies. And he was within a mile or a half mile or something like that of each one at the time that they occurred. So that was some of the information or evidence that they used against him at trial. During the trial, before the government introduced that evidence against him, he asks the court to exclude that evidence. He says that was not gathered constitutionally. In other words, the government should have gotten a warrant before they accessed my cell phone location information. And because they didn't, that violates the Fourth Amendment protection against unreasonable searches and seizures. Right? So remember, government can search if they have a search warrant. If they don't have a search warrant, the Fourth Amendment protects us from them conducting that search. In this case, there was no warrant. They just asked the cell phone company to give them the data. The cell phone company gave it to them. We get to trial and Carpenter says, hold up a second. I think that them accessing that data is a search. And I think that they should have had to have gotten a warrant. And because they didn't, I believe it's inadmissible. They can't use it against me. That was his argument at trial. The trial court did not accept that argument. And they allowed that evidence to come in during his trial. He was convicted and he appealed. So remember, when someone appeals, they're not appealing the facts of the case. We're not redoing the evidence. The appeal is that the judge in the trial court made a mistake. All right, so Carpenter's not saying we're not relitigating where he was at the time of the robberies. We're not putting on evidence of robberies. He's saying on appeal, the judge made a mistake when the judge allowed that evidence to come in. because it should have been obtained with a warrant. That was the issue on appeal. We're not calling witnesses. We're not going back over what happened. We're going over whether or not the judge at the trial court made a mistake. So that was his issue on appeal. The Sixth Circuit Court of Appeals found also or affirmed the trial court's ruling. So they also thought that it was proper for the government to be able to get the cell phone location information without a warrant. He appealed again to the U.S. Supreme Court. And the U.S. Supreme Court said, you know what? We agree with Carpenter. Getting 5 days worth of cell phone location information, that is what we would constitute as a search. The detail and the precise location that we can get with 5 days of information, we can now paint a very intimate picture of where a person's been, what they've done, who they have interacted with. And that is something that citizens have an expectation of privacy in, and the government can't just go get that and paint that picture without a warrant. And that's the overview of this case. So let's break it down for a second. This article gives you the legal background first. Here are the cases that the Supreme Court used that they thought were precedent and that they could either use to uphold their decision or distinguish to justify their different decision. So there were three cases that they talk about at first: the United States versus Miller, Smith versus Maryland, and the United States versus Jones. Miller and Maryland involved business records. All right, does anybody tell me what kind of records were at issue in either Miller or the Maryland case? Banking records for Miller, right? Okay. In that case, the government obtained bank statements from the bank without a warrant. The defendant in that case said, I think that constitutes a search, and they should have had a warrant before they accessed that information. The government won that case. Why'd they win that one, Mr. Garcia?
Because it's a business record, it's a third party.
Right, the business record belongs to a third party.
And it's not his information that you're sharing.
Right, it wasn't Mr. Miller's information, it was the bank's information they were getting. That was the rationale that they used. And what came out of that was something known as the third party doctrine. And so cases that involve records from businesses, the court said, we don't need a warrant for those because, number one, they're business records. Number two, they belong to the business. And number three, what is it about the banking customer and the bank and our expectation of privacy in our statements? I mean, we know that's not going to be private, right? We make deposits with them voluntarily. We write checks voluntarily. This is not private information. Okay? So how does that differ then with the Carpenter case? Because the Carpenter case involves third-party records. They belong to the cell phone company, right? So if you are the government's lawyer, you're saying, hey, this is just like the third-party doctrine cases. We've got a business that owns these records, and that's what we did. Judge, this is just like bank statements. This is just like outgoing telephone calls. That was the issue in the Maryland case or the Jones case. What is it that the court said is different this time in the Carpenter case than those other cases? Say that again? They're tracking them how? Right, and what was different about somebody making outgoing phone calls than somebody just riding around in their car with their phone on? Yes, Dylan.
When you make a phone call, you know that the number that you dialed is recorded.
Right.
But just having your phone with you doesn't, you're not saying, oh, okay, well, yeah, you can track me wherever I go just because I have to have my phone to be a functioning member of society.
That's exactly right. That's exactly what the court said. The court said there's a big difference between you making outgoing calls or you making deposits where you're voluntarily giving up this information or voluntarily taking these actions that expose who you're calling or whatever you're doing. But riding around with your phone, that phone is pinging cell towers when you pick it up for sure, but even when you're not picking it up. And the court said this is something that requires a warrant because we feel like this is an invasion of privacy to be able to paint this intimate a picture about somebody's whereabouts when it's not all voluntary. Okay? If the government had asked the cell phone company for just Mr. Carpenter's outgoing phone call log, then the government could have used the Jones case and said, this is exactly like that case. We're not asking for anything other than what he voluntarily put out there. But that's not what they asked for. They asked for the location data, which includes some voluntary things, but also a lot of involuntary tracking as well. Okay. The court goes on to say, cell phones are like a part of the body, right? In distinguishing cell phones from just a GPS tracker. Because there's some cases they had to deal with about GPS tracking too. But cell phones just represent a different level of access and intimacy to our whereabouts that you don't find from an outgoing call log or bank records or I forgot what I was going to say. All right, so let me look through this case and see if there are other things that I wanted you to appreciate. I think it's interesting that in the majority opinion, Chief Justice Roberts, who wrote the majority opinion in this case is a 2018 case, by the way, it's fairly recent, lays out sort of the history of how the Fourth Amendment has been interpreted. And he says it's evolved from its early days where it related very closely to the idea of common law trespass to now this interpretation where we look at it as where does a person have a reasonable expectation of privacy? Okay? And the realization that the Fourth Amendment is now interpreted as protecting people, not places. Right? I think I'd mentioned that at the beginning. Back in the day, it was easier for us to think about searches being in terms of physical searches and places and actual brick and mortar locations. But that's not the reality that we have. That's not the reality we live in. And we have a reasonable expectation of privacy in much more than just our physical dwelling, physical person. So that's the idea that the Fourth Amendment now protects people, not just places, people and places. The court is very careful to say that the issue before them is whether or not the government needed a warrant to get 5 days worth of cell phone location data. Justice Roberts says we need not decide whether anything less than that requires a warrant because that's not the question we're presented with today. All right, so my question to you, and we're going to go around, I want to hear from you, is how much is too much? How much requires a warrant? Less than 5 days. Is it 1 day? Is it 1 hour? Is it 30 seconds? At what point does the search require, or at what point does the search get protection under the Fourth Amendment? At what point does it become a search? When it's 30 seconds worth of information, when it's 1 minute, when it's a day, 2 days, when it's 3 days. You may disagree with Justice Roberts, and you may think it takes more than 5 days before you believe the Fourth Amendment should kick in. So I'm curious to hear what you would rule and kind of why briefly. So I'm probably going to walk around so that my phone can pick up. I'm not going to put y'all on video. You don't want to be. But Hoffa, what is your thought?
I really feel like any time could disclose information that I find private that would not pertain to the case. So
What if it's 10 seconds of your cell phone location information?
yeah, I'd say any
Still need a warrant?
Knowing where, getting that location of where I was at that time. 1 second. That's more than they need to see that.
Okay.
That's more as well.
All right. There are no wrong answers. I'm just curious as to your thinking and the rationale that the court uses versus what you think. What do you think, Ms. Hackett? You want to be on video?
Well, since it was being shown, when you was talking, my mind is not here.
All right.
So when you was talking, I was hearing, but I was not hearing at the same time. But I was trying to hear, but my head was thinking about a whole bunch of other things.
Me too. I had to lock in when we walked out.
Yeah, it's hard.
That's an honest answer, and
I try so
the
hard
people
to-
in the back are lucky because they're getting time to think about it, right?
Yeah.
All right. Is that all right, Roberts? You're Chief Justice Roberts. Here we go.
I say half a day.
Half a day? What is it about less than half a day that you think you don't have a reasonable expectation of privacy in?
I don't know. I just think if it's more than a day, they're getting information about a whole day of your actions.
Okay. And I think the court talks a lot about that, this mosaic theory, that the longer it goes, the more data they have, the more complete picture they can paint. All right? If they just find out where I am at 8:34 on a Tuesday morning, that's just where I was at that point in time. But if they know where I was after that and after that and after that, then all of a sudden they're tracking me in a way that maybe I have an expectation of privacy in. All right, Ms. Stewart.
I agree. I forgot his name, but I agree with him
You
about.
good with Hoffa?
Yeah, Hoffa.
All right. Jimmy.
I agree that no level of I haven't given any level of consent for them to access my records at any time.
Okay.
So if they're gonna use a cell tower as some kind of evidence, I feel like I would need to consent to that because I have my phone on me at all times.
And what about if they just wanted your outgoing calls? You think that's different?
I think if I was I don't know, it depends, honestly. If I was under fire for something and I know that I didn't do it, I would give them the okay, okay,
Yeah.
y'all have the consent. But if I know they're trying to accuse me of something that I didn't do and it's just it's getting excessive to the point where they're trying to take me back.
You may not know why they want it.
Yeah,
If they
true.
get it without a warrant, you don't even know that they're getting it,
Yeah.
right?
Mm-hmm.
All right, Ms. Green.
I think none.
None, okay?
None. Like if it's not under warrant and you didn't get approval for it, and it's not something that's already like the bank statements or the outgoing
Mhm.
calls, then you need a warrant no matter the amount. But also, my question would be when they get a warrant, does it have to be for surveillance stuff too? Like if you were going to store, and they pieced it together?
So that's a great question. They could need a warrant for some surveillance depending on how much it intrudes into your privacy. So they don't need a warrant to sit outside your house and see if you're coming and going.
Okay.
But they do need a warrant to peer inside, like if they're using a telescope to look inside your house. There's a case that this case references called Kelo versus United States, and that was one where the government used thermal imaging to search a drug house, a grow house. And they could tell from thermal imaging that there was this abnormal amount of heat, and that the only explanation for that was that they were growing weed in there. And so they went in and arrested them, and the defendant said, that was a search of my house.
Yeah.
And a court agreed that needed to have a warrant.
Why would you not get a warrant?
So that's a point I was making to y'all on Tuesday. Just get a warrant.
Yeah, like is it a hard process?
It's not a hard process.
Okay.
And if you have, the standard for a warrant is probable cause, right? So that's not a high standard. I mean, you just got to go tell a judge why you reasonably think this might lead to evidence, and the judge is almost always going to say yes. So get a warrant. So a lot of what we're talking about, right, this case never would have come about if the government had gotten a warrant for the cell phone location records. But at that time, they did this routinely because the courts found that they did not need one for it. So somebody finally challenged it and changed the law on it. All right. This is Miss Mills.
Yes, hi. I agree with what Brianna and Unique and Hoppo were saying. Even 1 second, that's a search. Like you're going in to find something, you should just get a warrant to
Okay.
find it.
All right. Good answer. Mr. Hernandez?
I mean, I feel like I kind of go with that as well. But like, if y'all were to look at stuff, I would look at like 3-day range, possibly, because I mean, if they're committing it first day, then who knows what they're doing after that, right?
So you feel like you feel like anything less than 3 days probably needs a search, but once you get to 3 days, you feel pretty certain that's enough.
Yes.
Gotcha. All right, Hackett. I mean, you're not Mr. Hackett. I'm sorry. Zach is what I meant to say.
I'd say like at least a day or two. Or going back to what she said, like if you don't find what you need in like a day or two, then I mean.
I like that. Then you're not doing very good.
Yeah.
All right, Mr. Elrod.
I feel like you need one immediately.
Immediately. All right, so even for a second.
Yes,
All right.
absolutely.
All right, I can get with that. Garcia?
Well, for me, it depends.
You know, I like that answer. It depends.
Because I know some of the more like violent crimes, being able to just access that information would help with it, like murder. But if it's a less violent crime, I can see them needing one immediately. However, I also know the flip side of that, of you can use that violent crime excuse to just get information for whatever.
Right.
And my first thought is you can also use the evidence in whatever way you want. Because I have seen some people kind of twist it of, oh, he was in the area, so he must have done it, even if he was just walking by.
Mm-hmm.
So, like I said, it kind of depends, but I also see getting it immediately would most likely be the best.
So I like that you brought up, so the Fourth Amendment, we're focusing on our individual right to privacy. And Caleb's talking a little bit about the government has an interest and a right in protecting us from violent crime, and there might be some legitimate reasons why they might need to do this without a warrant. So, I mean, we're balancing those things. But Miss Landrum's making faces, so I'm gonna go on to her.
I'm not photogenic, you know, like, you know.
All right, I put it on me.
Okay.
I put it on me.
I think I agree with Hoffa and those two down there. I don't think you could put a measure on like the privacy and all that.
So 1
Even
second is too much.
that's too
Get a
much.
warrant.
You get a warrant.
All right. Particularly because, as Ms. Green was pointing out, and Ms. Mills, just get a warrant.
Right.
It's
Not
just,
that hard.
it's not like sometimes the government can get away with not getting a warrant if some of the exceptions are like if the evidence is about to be destroyed or but there's nothing about cell phone location records that are going to disappear, right? I mean, I think the article says that cell phone companies keep this stuff for 5 years, 10 years, 7 years. So you could basically paint a picture of where Chapman has been for 7 years. You don't want that? Not a good idea? All right, we don't want to know? All right, Mr. Cruz, what do you say?
I think that they should be able to get information without a warrant for at least just 1 day, because usually the more violent crimes are just like sometimes spontaneous.
Mm-hmm.
So within a day, you can obtain so much, but sometimes there are things that it spans over so much that you might need to get more complicated.
Mhm.
So that's where you
Gotcha.
need a warrant.
Okay, you're getting a lot more information once you get past today, for sure,
Yeah.
right? The more information you're getting, the more our privacy is invaded. Mr. Wynn, what do you say?
Yeah, I think you should just get a warrant. Not gonna lie.
Just get a warrant?
Yeah.
All right, so if anything less, anything more than 1 second,
Yeah.
get a warrant.
Yeah.
All right? What do you think, Miss Morales?
Well, at first I thought, okay, 3 days, like, but after hearing everyone else and like just thinking, a second, like, get a warrant. Because if I'm at therapy or at the hospital, like, that is protected, like, itself. And if the government knows that, like, I'm going to therapy or going to the hospital for certain things, like, that right there is private. But if they know, then, like, they're invading my privacy.
Okay.
So definitely a
I
second.
like that, and I like that she's changed her mind based on y'all's discussion. That is why we're doing this. All right, Chapman.
All right.
7 years?
First of all, you got to be a smarter criminal than that. Get you a burner phone, get you one you can crush and throw away. But I mean, if they think you're that guy, I mean, just go ahead and.
So
just do whatever
Carpenter's
you gotta
got
do.
some fault here. He should
yeah.
he should have
For sure.
been a lot more careful than
That's
that.
right.
All right, but do they need a warrant? Did they need a warrant for 5 days?
I mean, probably. Just go ahead and get one.
Just go ahead and get
But
one.
I think you're that guy. Just go ahead and keep tracking. Just go as you go.
He had something he was hiding there, right?
That's right.
Right. Okay. All right. Yes, sir.
I feel like it should either be protected by the Fourth Amendment or not, and not be like 10 seconds a day, an hour. 'Cause
Gotcha.
What if they come search my house for an hour before they need a warrant? Like, just either on
So
or
we
off
shouldn't
sort of
put
thing.
time limits on it. That it's either needs a warrant or doesn't.
Yeah, like either it's Fourth Amendment or it's not.
Okay. You're getting a lot of nods on that. I think that's pretty solid. Green.
I agree with everyone. You got probable
You agree with everyone?
Yeah. Just get a warrant. If they got probable cause, just get a warrant.
Just get a warrant?
Yeah.
Okay. So no level of information is okay without the warrant.
Yeah.
All right.
I'd say so.
Okay. All right, Ms. Swint, what do you say?
I mean, I agree with the majority because, like what you said earlier about like how the phone is basically like a part of your body. Like I feel like that's an invasion of your privacy because it's part of you. So
It's a little scary, isn't it?
It's very scary. Like I got to looking around, like dang, everybody do got their phones like right there on them. Like it's kind of crazy, but I just say get the warrant immediately.
I mean, there's no place we don't take it.
It's
really
crazy, actually. But
unless we're smart criminals. All right, Dylan.
I mean, at this point, I don't think there's much to say. I mean, yeah, I think that it should be protected at 0 seconds. Like, it's like reaching into somebody's mind and pulling out their diary. Like,
yes,
it's not something that you can protect. Like, we can't lock that up. You know,
That's right.
Like, and also from this case, like, everything sends data. Like, even our computers are sending data right now. Like, and we need all of this. So, like, I don't think it's something that you can just be like, well, just don't use your phone.
I think those are great points. See, there was plenty more to say. I think it's interesting that the the authors of the Fourth Amendment 200 years ago, they had no idea that this was going to be interpreted and applied in the way that we do it now. In some ways, it's a testament to the way that our Constitution has been able to survive and live for this long. Because there's no way when they're talking about searches and seizures, they would have even had any comprehension of online presence or these other areas where we store personal data. All right, Mr. Eason.
What's the question?
The question is, how much cell phone location data should the government be allowed to get without a warrant?
How much cell phone location data?
In this case, it was 5 days worth, and they found that they needed a warrant for that.
5 days worth. I think it should be like at least 4 days.
At least 4 days?
At least 4 days, because
Are you okay with the government getting 3 days of your cell phone location information without a warrant? No. No? All right. What about 2 days?
not at all.
What about 1 day?
Not in the slightest.
What about 30 seconds? All right, so you come down with most everybody in here, which is it's either protected or it's not. And we're not going to put a sliding scale on it, so to speak. All right, very good input. And I apologize for filming y'all up close. I did leave my microphones at home today. So we do this very often. I love to throw out a case and discuss it and then have y'all be the jury or the judge and tell me what you think. And I love how, if I started over again with Hoffa, maybe everybody's answers might be a little bit different because of the other perspectives that you've heard. So I think that's cool. My next question is, does anybody have any questions about anything in the case? Something Mr. Spalding said reminds me, or something I wanted to read from you on here. A cell phone logs cell site record just by virtue of it being in operation without any affirmative act on the part of the user other than powering it on. Apart from disconnecting the phone from the network, there's no way to avoid leaving behind a trail of location data. And I don't know if that was the passage I wanted. Oh, this is it. The timestamp data provides an intimate window into a person's life, revealing not only his particular movements, but through them, his familial, political, professional, religious, and sexual associations. It's more than just where you are. They're able to make inferences and paint a much more detailed picture than just where you are through that. So, this is a little bit off topic, but it occurred to me while we were walking through here. And I'm asking you, I guess, if you know more about this than me. I'm telling you I don't know a lot about it. But don't our cell phones, isn't there some capacity where they're listening and that feeds into the algorithm on content we get? Is anybody well versed in this? Y'all know about this? Dylan, you know about this? A little bit. Is there a way is that an automatic feature of every phone now? Is there a way to turn it off? I mean, you can't turn it off.
Yeah, it's not even really a stated feature of it. It is in terms of service agreements that we all agree to, and like when you first get an iPhone. I don't know if anybody remembers this, but there's you just scroll through the terms of service and then accept it, and you never read it. Nobody wants to. In it, there is like a single sentence about the microphone usage and how it's used for there's some specific wording for it, but it says that it's for Siri only. But I mean, let's be honest, we all know that it's not just for Siri anymore.
Well, and that leads me to the question of what all do they store besides just the cell phone location information? Do they store the actual texts and emails and things like that? Is there a way could someone go in and say, what's the algorithm think about Tebow? I mean, I'm curious from the standpoint of privacy. What all could they learn about me from this phone?
And what all could they predict about you?
And what could they predict about me?
Yeah. That's the scary thing.
Not just the bad things I've done, but the bad things I might do, right? It's very scary. But I am encouraged that the Supreme Court does seem to be evolving the Fourth Amendment protections as with technology, right? We went from something like an outgoing call log or bank records where they were like, don't really have an expectation of privacy in that, to things like tracking our every movement. Yes, and I think that's why those of you who feel so strongly about even a short time period of location information needing being protected. It's just it feels like we're being watched because we really are. Does anybody have any thoughts, comments, things to say on that case.
I feel like my brain is kind of in between, in a way. If I want to think broadly, like it's kind of like, well, when it comes to crime, it's actually very useful.
Right. So I love that you're saying that. I mean,
But as a person, it's kind of like we don't want to be surveillance.
Yes.
But it's like it's actually useful.
we have viewed this mostly from a personal standpoint, right? If I told you you had to be the lawyer for the government, you might not subscribe to this belief, but the argument you would make is we need to be able to know what people are doing for public safety, right? I mean, that's the argument we would make. So I love that you brought that up. We were mostly giving our opinion as private citizens. I was not asking you to give your opinion as from a public safety or a government standpoint. But we could make arguments as to why it might be in the overall public good for the government to be able to get some of that information. There are two sides to it for sure. Let me find real quick. I got a couple minutes. Some fact patterns that involve criminal law. Oh, you know what? I think we need to cover the Georgia criminal statutes. So y'all pull those up. I'm trying to figure out how I can pull them up. How I can sign into Cougar View without my phone, which I don't think I can. Let me see if I can get at this a different way. I don't know that I can get there. All right, I think that'll have to just